Hi, good evening, Vinay sir. Good evening, everyone. Am I audible?
Good evening, madam. You are very much audible. Am I audible?
Yes, you are audible, sir. So we can wait for 5 more minutes, and we can.
Yes.
Yeah.
Okay.
Hi, Pramod Kumar sir. We have not started the webinar yet. We'll start in few minutes. Hello, Vinay sir. Shall we start the session?
Yes, let's start.
Warm welcome everyone to the National Tax Lecture series of organized by TaxCan. And we have here Advocate Vinay Sharav sir as a speaker. And on behalf of TaxCan and all of you, I welcome Vinay sir. And over to you, sir.
Yeah, thank you. So today we are going to talk about how to handle so-called notice, appeal, what are the circumstances in which we should approach the writ court, whether in the case of issue of the so-called notice or the appeal or the order in original. What are the situation in which instead of replying to the so-called notice or filing appeal against the order, we should approach writ court, and what are the basic some of the basic features of the SLP which can be filed before the Honorable Supreme Court against the order of the High Court. So what is the meaning of the SLP? In fact, the basic fundamental meaning of the SLP, the meaning of the writ petition, what circumstances we can approach the High Court with the writ petition, what is the time limit within which the writ petition can be filed, against whom, how to appear before a authority or a tribunal or a writ court, what are the do's and don'ts while filing the reply or drafting of the appeal and all that. And I will also show a sample reply, the manner in which I do it. So to start with, the so-called notice is the fulcrum of the initiation of the litigation under the GST law. Now the question is, what do we do when we receive the so-called notice? And what is the format of the so-called notice? So, but before we discuss that, I want to tell you that in terms of Rule 142, 1 capital A, till 14th of October 2020, the GST rule said that the authorities must issue a pre-so-called notice in Form GST GST DRC 01A. The so-called notice is issued in Form GST DRC 01. But prior to that, earlier the rule said that this Form GST DRC 01A shall be issued, which means that it was mandatory to issue Form DRC 01A, but with effect from 15th of October 2020, the word shall has been replaced by the word may. So it appears that now the mandatory requirement of the issue of the Form GST DRC 01A has been dispensed with. But my opinion is that the word shall, even if it has been replaced with the word may, still in my opinion, it is mandatory to issue a notice pre-so-called consultation in Form DRC 01A. The reason I say so is that the objective of issue of notice in Form DRC 01A was and is that it is the objective is to reduce litigation between the department and the SSC. A pre-so-called consultation was mandated even under the service tax and central excise regime, whereby if the amount of the demand exceeded 50 lakhs, then free so-called consultation was mandatory by virtue of a circular. Now, under the GST Act, this form DRC 01A was introduced. And in my opinion, it should be considered as a mandatory requirement because it is in the benefit of both the department as well as in the benefit of the SSC. It affords an opportunity to the SSC to submit a preliminary reply so that if the department is satisfied, then there is no further litigation between the department and the SSC. Furthermore, Section 73 as well as the 74 gives the benefit of reduced penalty or waiver of the so-called notice itself if the tax and interest is paid before the issue of the notice in form DRC 01. So if it is considered that DRC 01A is not required to be issued at all, then how will one avail the benefit of the reduced penalty in terms of Section 73(5) and Section 74(5), which says that if you make the payment of the tax, suppose a demand or the intimation of tax ascertained is issued in form DRC 01A, and if for some reason, due to clerical error or some unintended reason, there is some error on part of the SSC, so he can choose to make payment of the tax and interest if there is no element of fraud and misstatement. So if that be the case, that he pays the tax immediately on issue of DRC 01A, then no further so-called notice can be issued to him and all proceedings will be concluded. So he is saved from penal proceeding. But even if suppose there is a allegation of fraud and misstatement, even then, before the formal issue of the notice in DRC 01, the SSC can choose to make payment of the tax and interest along with the penalty only of 15% of the disputed amount. And even in that case, the proceedings will be concluded and no further so-called notice will be issued to me. And for this reason, I believe that unless the DRC 01A is issued, one can never avail the benefit of this reduced penalty, which is mandated or a choice is given to the SSC in Section 73 as well as in Section 74. But let us suppose that this DRC 01 is issued. Even then, the SSC can choose to make payment of the tax within 30 days of the issue of the notice. And even in that case, he will be entitled to a benefit of reduced penalty of the 25% of the amount, disputed amount, if there is an allegation of fraud and misstatement. So suppose the formal notice in DRC 01A is issued, then the penalty amount increases by 10% in the case of allegation of fraud and misstatement. So it is always advisable that if one feels that the demand which is made by the department is justifiable, there is no point in entering into unnecessary litigation, and better to close the matter as soon as possible so that one can avail the benefit of the reduced penalty. Okay, somebody is asking whether DRC 01A is helpful to the taxpayer. Based on defense of the taxpayer in DRC 01A, department modifies its DRC 01 but never drop SCN. I would say that one should always avail the benefit of DRC 01A because the department can modify its DRC 01 only if you give a very long drawn reply and giving a lot of ideas to the department to improve upon its so-called notice. But if you restrict your reply to bringing on record the factual aspects and bringing on record some expert evidence, then in that case, it is always a opportunity to you prior to the formal issue of the so cause notice. And if the department ignores your reply and does not deal with your reply, then DRC 01 itself can be said to be without application of mind, and one can seek quashing of the DRC 01 for that reason alone. Because if you have given a proper response, brought on record factual aspects, factually suppose some there is a error in the demand being made, or you wish to bring on record certain documentary evidence in support of whatever you wish to state, then it goes to your benefit and not to the benefit of the department. But yes, one should not make a very detailed reply in the sense that it should not be with all the judgments and everything which we wish to rely upon, so that the department may not improve upon the so cause notice. And yes, one more important aspect is that if the even if after the notice within 30 days, if the tax interest and the in case of the allegation of the fraud, the reduced penalty of 25% is paid, then all the proceedings will be concluded except the proceeding under section 132, and even the proceeding against the director, if initiated with respect to the penal proceeding, even that has to be closed. So one can also avail the benefit of not entering into litigation and taking the benefit of the reduced penalty even after the issue of the so cause notice. Now coming to the filing of the appeal, I will discuss about what circumstances one can avail the benefit of the filing of the writ, even at the stage of so cause or even at the stage of the order in original. But before I do that, let me tell you some elementary aspects of the filing of the appeal. The appeal has to be filed in form GST APL 01 within 3 months of the date of the communication of the order to you. So date of the receipt of the order is very, very important to count the limitation period of filing of the appeal. So one should never discard the envelope in which the order is received if the order is received by post, and if it is uploaded on the portal or in the through email, then one should save that evidence also, because the limitation period starts from the date of communication and it is not from the date of the passing of the order. And it is also important that the order is uploaded in the portal, because if it is suppose served upon you by post, or if it even if it is mailed to you, but if it is not uploaded, then I'm sure you are aware that the only mode of filing appeal is the electronic mode through the portal. So until unless the order in original is uploaded on the portal, even then the limitation period will not commence, because now you are debarred from filing appeal on in the manual or any other mode. Only mode which is permitted is the virtual mode. So effectively, the limitation starts from the day the order is uploaded on the portal. So if the order is not uploaded on the portal, if you receive the order on through email or by post, then you should immediately write to the authority to upload in the portal. Okay, Mr. Gupta is asking whether if it is emailed, that will also not count. Yes, if it is emailed, it will not count. There are several judgments of various high courts where one could not file the appeal within the limitation period as prescribed in the law. But still, the court said that until unless the order is uploaded in the portal, since the only mode of filing appeal is electronic mode, so until unless it is uploaded on the portal, the limitation period will not commence. So there are judgments of the Gujarat High Court, Calcutta High Court, and several other high courts. So you can refer to them. Now, another important aspect of the filing of the appeal is that you must make a payment of the pre-deposit of 10% of the disputed tax amount, subject to a maximum 25 crores. So it is 10% of only the disputed tax amount and not the disputed tax, interest, and penalty amount. So that is to be kept in mind. And against the order of the appellate authority, since the tribunal is not constituted, one can approach the High Court. Because ordinarily, if there is an alternate remedy, then the High Court does not entertain the writ petition. But if since the tribunal has not been constituted, so one can approach the High Court. Now, with respect to the approaching the High Court, the Bombay High Court has said that the Bombay High Court has issued a very well-drawn order, even though it is applicable only to the jurisdiction of the Bombay High Court. But the Bombay High Court has said that if the 20% of the further amount, so 10% plus another 20%. So if total 30% of the amount, disputed tax amount, is deposited after the appellate order has been passed, then the department should not initiate any recovery proceeding, and the demand should be automatically stayed, because the GST Act says that on the payment of the further 20%, that is total 30% of the disputed amount, there will be automatic stay on the recovery of the proceeding. Yes. Somebody is asking that if the demand is confirmed only for interest or penalty, then whether pre-deposit is required. So let us have a look at section 107. What does it say? It says that no appeal shall be filed unless the appellant has paid a sum equal to the 10% of the remaining amount of the tax in dispute. So it only talks about tax in dispute and does not talk about the penalty amount. But it says that no appeal shall be filed against an order under section 3 of section 129 unless a sum equivalent to 25% of the penalty has been paid by the appellant. So only in case of the penalty imposed under section 129, 25% of the disputed 25% of the disputed penalty amount has to be paid. But otherwise, if only there is a demand of interest and penalty, then no pre-deposit is required to be made. Now, one more thing I wish to add is that many a time it is happening that either the original authority or the appellate authority even if the justifiable reason is shown for seeking adjournment, they are not granting the adjournment and passing the order. So if that be the case, then such an order is contrary to the provision of law as well as the violation of the principle of natural justice, and it is liable to be set aside on that ground alone from the High Court. So if the ordinary original, the adjudicating authority does not grant you the adjournment for at least 3 times, provided you show the justifiable reason for seeking such adjournment, and ignoring that if an order is passed, then it should be set aside. Now, regarding the drafting of the so-called notice, I think one of the most powerful and one of the most important aspects before you begin your drafting is to understand the facts of the case first. And in order to do that, I think one of the most important thing is that you ask the client to give you all the documents. And I'm saying so from my personal experience and what I personally follow. Sometimes it so happens that clients provide all the documents over the email. But in the email, there is a possibility that some important document escapes your attention, something printout is not taken at your end, or some or other important fact is missed out. So it is important that you tell the client from the day one of the commencement of the dispute, whether the so-called notice has arose out of any investigation or search and seizure or audit proceeding or say summon proceeding, whatever may be the case, you should ask for all the documents from the day one of the commencement of the dispute when the department writes its first mail or letter or any other communication to the SAC, and whatever the response the SAC has made, whatever documents they have submitted. So ask them to make an index of all the document, collect all the document. First thing you must do is to draw the fact, ascertain the fact, arrange all the documents chronologically in order of the date, make a list of date, and then only we start drafting the reply. Because unless you have all the facts in your control, it is not advisable to straight away jump to the drafting of the reply just because the client is pushing you to draft the reply. Another aspect is that many a time it so happens that the department gives a very limited time to file the reply, maybe 5 days, 7 days, or 10 days, or even a month. But the time is not sufficient to draft the reply. Then it is your right to seek a reasonable time to respond to the reply. Because if they don't give you an adjournment and proceeds to pass the order ignoring your request for a reasonable adjournment, then it is certainly a violation of the principle of natural justice, and such an order or any decision of the department is going to go against them, and it will be liable to be set aside. So you should always keep in mind that any reasonable demand to seek or enforcement of your right to seek adjournment cannot be denied by the department. So you should not be pressurized unnecessarily for want of time, and always seek a reasonable time to understand the fact, gather the fact, and do your research work with respect to the relevant provision of the law. while doing the research work on the applicable provision, I think you must be aware that whatever section is applied, there are almost all the journal which allows you to do a research on the section wise or rule wise research on that particular provision of the law. So that also must be done so that you have on your fingertips what all judgments, whether for you or against you, has been decided. It is also important to know the judgments which are decided against you so that you deal with those points which are not in your favor on the basis of your own understanding or the basis of some other judgment which is contrary to the judgment which is not in your favor. So it is so before you begin your drafting of the reply, it is very essential to understand the fact, to fully do a complete thorough research on all the aspects of the point of law or the proposition of law which you wish to advance, and then only you draft the reply. And it is very important that you should not miss out on any allegation which is made in the so-called notice. All the allegation, even if they are absurd, they should be dealt with. Now, there are some technical aspects which I wish to discuss before I will show you one of the draft reply, but some of the technical aspect I wish to deal with. For example, many a times the so-called notice relies upon statement of a third party. Or suppose your own statement. So if it is your statement of the client itself, and if that statement is taken under force or under threat, then the immediately one should do is to retract that statement, stating that the statement was not voluntary and it should form part of the reply to your notice. That is point number one. If there is a statement of third party which has been relied upon, then at the earliest possible opportunity before the matter is adjudicated upon, you should seek a cross-examination, so that if third party's statement is relied upon for anything, then if the cross-examination is done, then you will be able to deal with the allegation made against you. And if they don't give the benefit of the cross-examination, then that is a good enough reason to get the entire proceeding quashed. Let me tell you, there are a number of judgments of various high courts in the context of sales tax, central excise, and income tax, whereby if the third party statement is relied upon and the benefit of cross-examination is not given, then such a order is liable to be set aside on that ground itself without entering into the merits of the case. And the benefit of cross-examination, I just give you one example from my personal experience. Recently, in one of the matter, the department alleged that you denied the input tax credit on the ground that they said that the transporter has denied that he ever transported the goods for you. I sought a cross-examination of the transporter. The transporter was made to sit face to face with the SAC. Now, before the officer, when the cross-examination took place, the transporter said that I was not able to recall from my memory earlier, because obviously he was under the pressure from the departmental officer, and therefore he gave a false statement. But ultimately, when he was cross-examined, he admitted that he in fact transported the goods for the SAC. Another important factor is that if suppose it is a matter if any factual allegation is made against you, and it is such a matter which is the domain of a subject matter expert, then it is always advisable to seek an opinion or a certificate from such an expert. If it is a matter of, say, technical in nature, then it is always good to have a certificate of a engineer, chartered engineer or something like that. And if it is a matter relating to finance, accounts or something like that, then one can seek an opinion of the chartered accountant. So all these things I am telling you that they should be dealt with at the first instance while filing of the reply. So whether it is a matter of the certificate of an expert or cross-examination or say retraction of the statement, all of them should be dealt with first hand at the time of dealing with the reply itself. Now, another important aspect we should keep in mind is that if you don't produce all the documents or whatever evidence you wish to seek to rely upon at the time of filing of the reply, then before the appellate authority, you are not allowed to produce any additional evidence, even though one can argue on the point of law before appellate authority or before high court or the tribunal. Even if those point of law we are not urged before the lower authority, but with respect to the facts, it is important that all the evidences, whether it is oral or documentary, oral means a statement of a third party, documentary means suppose any documents which is relied upon. So suppose if any relied upon documents are used against you, then you should also seek a copy of the relied upon documents from the department before you commence the reply to the so-called notice, because if the relied upon documents are not supplied to you, then that also is a good ground to set aside such an order. So it is very important that you produce all the evidences before the original authority, because if you don't do so, then except in some circumstances, which is there in this particular slide, which says that where you are prevented by sufficient cause, or where the opportunity was not given to you, or the department did not ask for such a document which was relied upon, only then before appellate authority it will be allowed, otherwise not. Now, as far as the drafting of the reply is concerned, I want to take you through one of the draft reply, the manner in which I do. So I'm closing this slide for the time being, and I will take you through one of the draft reply. Just wait for a moment. I'm just sharing the screen. Yes, can you see that reply? Yes, participant can now see. So let us have a look at it. So you address the officer, then you say ki you are in receipt of the so cause notice requiring you to show cause as to why. So the allegation which is usually made at the end of the so cause notice, it is reproduced at the top as to what is the amount of tax which is demanded, for what reason, then interest and penalty which is demanded, which is usually you will find it is at the bottom of the so cause notice. Then you state as to what are the allegation against you. So what is the revenues case? So that you state as to what is the ground or what are the reason on the basis of which the so cause notice has been issued to you. So those ground need not be verbatim as to the manner in which the so cause notice is drafted, but by and large, it should capture the essence of whatever allegation is leveled against you. Then you state the factual position. So what is the fact? So first of all, if there is any dispute about the facts, then you must bring on record the correct fact so as to enable the officer to appreciate the factual allegation against you. So you bring on record all the documents, expert certificate, suppose retraction of the statement or whatever facts related disputes are there, which you wish to bring on record, that you must do. And then you make your submission on the legal aspect. So while dealing with the legal aspect, I think the foremost important thing is to, first of all, you throw all the proposition of law in a broad head. So what are the proposition of law which you wish to rely upon? Depending on the interpretation of the particular provision of the law which you wish to rely upon or which the department has relied upon. Suppose the department has interpreted a particular provision in a particular manner and you dispute that, then why you dispute that proposition, that interpretation of the department, and what is your proposition of the law on the basis of which you are disputing it, you must bring to the fore in your reply, and point by point, heading by heading, you make all the proposition. Then if you think that the so cause notice is issued without jurisdiction, then you raise such jurisdictional point. Now that jurisdictional point also may be a point of limitation. So if the so cause notice is issued beyond the point of limitation, then that is also a point of jurisdiction and you must deal with that. Then you must state as to why the demand of interest is unsustainable. Then you must state why the penalty is not impossible. Now, with respect to imposition of penalty, let me tell you that penalty is not impossible when the issue involved is of interpretational nature. In this reply to the so cause itself, as you can see that there is this judgment of the Honorable Apex Court in Uniflex Cables Limited versus Commissioner of Central Excise, reported in 2011 271 ELT 161, which says that penalty is not impossible when the issue involved is of interpretational nature. And penalty is also not impossible if the department is aware of the fact. So unless and until there is a misstatement or any intent to defraud the revenue, even then the penalty cannot be imposed. So if you have with you any documentary evidence to show that the department was already aware of the facts of the case, then the penalty in that case also cannot be imposed. Then you make your prayer that the concerned officer should drop the proceeding in respect of so cause number so and so. Then you request and pray that there is no scope for extension of the period of limitation. And why? And you also pray for dropping the proceeding with respect to interest and penalty. And at the same time, I think it is customary to add a line that you crave leave to add, alter, or amend or modify the ground taken here. So, as because any additional ground can always be taken, so we must take those grounds. Now, to add to this, if suppose you omit to state any point of law or factual aspect in your reply, then it is always permissible till the matter is adjudicated to bring on record all those things through you in the course of hearing of the matter. So by virtue of the written submission also, I think one should not miss the opportunity of written submission, and always give written submission if you have anything to add in addition to what has already been replied. Now, the next issue is with respect to dealing of the okay, somebody is asking, please provide sample answer to reply to SCN with this PPT. It will be much helpful. Yes, I will do that. Certainly. I will do that. Okay, just give me one moment. I'm coming back. I'm coming back in a minute. Now, with respect to dealing with the filing of the appeal, all the principles which I have stated while drafting of the reply, all of them apply while filing of the appeal also. But while drafting of the appeal, you must keep in mind that you are dealing with the order now. You are not dealing with the so-called notice. One of the cardinal mistake which one makes is that one is still under the impression that you are still dealing with the reply. Suppose the so-called notice was issued on 5 grounds. Now, for some reason or other, maybe it may be the mistake of the adjudicating authority, but suppose he has reduced the allegation to so 2 or 3 grounds. So it is always the operative part of the order which you have to deal with. Now, in the order, there will be 3 sections. One will be what was the allegation in the so-called notice. Second will be what was the submission made by you. The submission made by you can be in 2 parts. One is as reply to the so-called notice. Second is what all submissions you made in the course of the hearing. Now, those submission may be your oral submission, your submission may be in form of the written submission. Now there will be an analysis and finding or the discussion part, which is called the operative part. So while drafting the appeal, you are always dealing with the operative part of the order. You are no more dealing with the allegations which were there against you in the show cause notice. Secondly, if there is anything in the order which travels beyond the show cause notice, whether either in terms of the amount which has been confirmed against you or the new grounds which have been added while confirming the order, then you should always keep in mind section 75 subsection subsection 7. Section 75 subsection 7 says the amount of interest, tax and penalty demanded in the order shall not be in excess of the amount specified in the notice, and no demand shall be confirmed on the grounds other than the ground specified in the notice. So neither the order can go beyond the notice with respect to the demand of the amount, nor it can go beyond the grounds. So both of which is impermissible in terms of section 75 subsection 7. You must check that, very thoroughly scrutinize the order. So if it has gone beyond, then you point it out, and that is a ground alone to get the such an order quashed. But if it is going below, which means some of the allegations which were there in the so-called notice are no more there in the operative part of the order, then you don't need to deal with that anymore and complicate the problem for you. You should assume that those allegations have been dropped. So this is very, very important while drafting the appeal. Now some of the other principles or the formula which you should adopt, or which I do, is that there should not be cut and paste just because the matter apparently appears to be the same. It is never the same, because the manner in which the so-called notice is drafted by different officer, or the manner in which any order is passed, even if the issue appears to be the same, no two order or no two so-called notices are same. So never make that mistake. Then in the eagerness to supply the information, you should not oversupply the information. So unwarranted information which is not even part of the allegation, you should not supply. It is very important to be polite in all your replies or filing of the reply. Even if suppose the grave injustice is done to you, intemperate language while filing the reply, or intemperate language just because you feel that now you are going to the appellate authority, so you can bash up the original authority, that should not be the approach. Because it is always better to be respectful to your opponent. Even if they are not, you should not be making any remarks which are not very pleasant in the manner of writing or while making an oral submission. Then also one should be properly dressed. If you are a chartered accountant, then you should be wearing a proper dress with usually a coat or a tie if it is very hot, and a white shirt and a black tie, something like that. So it should be pleasant and not very casual. Now, with respect to the manner of the representation or the oral hearing, one of the very important thing is to have a short note of chronological arguments which we are going to make. So you should have at your fingertips all the proposition of law which you are going to argue. You should have at your fingertips all the facts with the relevant page number of all the documents which you wish to draw attention of the concerned authority or the tribunal or the court. And speak softly and very clearly and slowly. Don't rush through your arguments. You may know a lot about the matter, but you can't expect that the authority who is conducting the hearing or the tribunal or the court also knows as much as you do. So you should be very slow to the extent possible. The manner of your submission. And if they ask any question, you should not interrupt them and say that I am going to cover it later on. Whatever question, even if it sounds stupid to you, you must answer the question and not debate or counter question or say that, sir, I will deal with it later on. That should never be the approach. Whatever question is being asked, that question or the query should be dealt with forthwith. And also, if you are going to rely upon several case laws, then it is better to make a compilation of the case laws with proper indexing. Give a copy to your opponent also, and give a copy to the judge or the tribunal member or the authority. And also, if possible, in that compilation, whatever relevant provision of the law is also there, that also should be part of that compilation with proper indexation and all. And yes, one more thing, that you should never read out the head notes, because the head notes are prepared by the those journals, and they sometime are wrong, and it is better to always refer to the relevant paragraph rather than to the head notes. So that mistake should never be made. Now, about what circumstances one can file a writ. Now, you should know that a writ lies before the High Court in case of a violation of a fundamental right or any statutory right. But if any statutory right is violated and you have an alternate remedy, then you cannot approach the High Court. So I will come to under what circumstances one can come to the writ court, even if suppose alternate remedy is there. But before that, let me tell you that you can also approach the High Court for inaction of the authority. Suppose if the authority is required to act within a particular period of time in accordance with the law, or if there is no time prescribed in the law to act, and the authority does not act within the reasonable point of time, and you have a statutory right with respect to enforce whatever you are seeking, then you can also approach the High Court with respect to that inaction. So it is not just the action of the order against which you approach the court, you also approach the writ court against the inaction. Now, one thing which one usually asks is that what is the timeline for filing of the writ? Let me tell you, there is no timeline prescribed under the Article 226 of the Constitution to approach the High Court. But yes, if suppose you are approaching the writ court against an order, then ideally it is advisable that you approach within the limitation of filing of the appeal against the order which you are approaching. Then with respect to the jurisdiction of the High Court, let me tell you that you can approach not only the High Court where the jurisdiction lies in terms of the geographical territory, territorial jurisdiction, what is called. But even if the small part of the cause of action arises within the territory of a High Court, then even if the part of the cause of action arises, one can approach the High Court in that particular jurisdiction of the High Court. Now, I'm dealing with various types of writs. So, writ of certiorari is usually when you make a writ against any order, and writ of mandamus is when we make a writ against, suppose, so-called notice or inaction of the department. Now, whenever we approach the writ court, there are two stages to it. One is the admission stage, and the second is the detailed hearing. So, at the first instance, when the admission hearing takes place, then it is not that writ remedy is your right. Unlike the appellate remedy, which is your right, writ remedy is not your right. So the court will first instance will like to hear from you as to why you have approached the writ. So once that admission part is done, only then the detailed hearing takes place in the subsequent hearing. Even though sometimes if the matter is small, the with the admission, the matter is also finally adjudicated. But usually, whenever a writ petition is filed, the court admits the writ petition, gives opportunity to the opponent to file an affidavit in opposition. That means they, as you make a writ petition in writing, they are also entitled to file a detailed response to your writ in writing. And then you gave a opportunity to file a rejoinder as to whatever opposition the other side files. So these are some of the elementary fundamental aspects of the writ code, which I thought I will discuss with you. Then one frequently asks as to what are the circumstances when at the so-called stage one can approach the writ code. Now the first instance is when the so-called notice is cryptic or unintelligible and not very clear. So if the allegation on the face of the so-called notice are not very clear or legible or not, you cannot make anything out of it except that some amount of tax, interest and penalty is demanded from you. How can you expect to furnish a reply? So the so-called notice must be a detailed so-called notice. In the GST era, we have seen that sometime only the form DRC-01 is issued without a detailed so-called notice. So DRC-01A is 01 or 01A is only the summary part of it. It has to be accompanied by a detailed so-called notice on, and unless that is done, the so-called notice is not valid and you can approach the writ court for quashing of such a so-called notice. And even if it is accompanied by a detailed so-called notice, but from reading of the so-called notice, you cannot make a head and tail of it, then also you can approach the writ court. Then you can also approach the writ court if the so-called notice is without jurisdiction. Without jurisdiction means suppose the officer who is issuing the notice to you has no jurisdiction over you. And also, if the so-called notice is beyond the period of limitation as it is specified in the law, then also it is liable to be quashed and set aside. For example, a note of so-called notices are coming in the earlier regime of service tax, where the limitation period is over. but still the department is demanding the service tax. So that is beyond limitation, and you can approach the writ court directly and get it quashed. Also, if the so-called notice is entirely on the basis of the third party information. For example, many a times the so-called notice is issued on the basis of 26 years. Now, such a so-called notice is invalid and likely to be set aside by the court directly without entering into the merit. Because the authority concerned is supposed to make an inquiry, and merely because it's some income has been earned, which is part of your balance sheet on profit and loss account, and you have paid income tax on it, it does not mean it is having the liability to pay GST or service tax also. So if that is there, then also you can approach the writ court. Also, if the so-called notice is directly contrary to any decision of the High Court or the Supreme Court or the tribunal, then also you can approach. Also, if you wish to challenge the virus of the act or the rule, for example, many of the demands relating to the input tax credit, whereby the demand is on the ground that the supplier has not made payment of the tax, the only remedy is to challenge the virus of section 16(2) subsection C. So if that be the case, then there is no point in filing reply to the so-called notice. You must challenge the act or the rule, whatever you wish to challenge. Lastly, in the so-called notice, from the language itself, it appears that the authority concerned has already made up its mind, and the so-called notice is an order in itself. Then also you can approach the writ court to get such a so-called notice quashed. And I have cited several Supreme Court judgment, or also a very recent judgment of the Honorable Calcutta High Court, which was argued by me, wherein the so-called notice was quashed on the ground that the so-called notice is premeditated, and it appears that the authority concerned has already made up its mind, and there is no chance of any fair hearing or fair treatment from the concerned authority. Now, under what circumstances you can approach the writ court against the order in original, even if it is appealable? Again, you can approach the writ court against an order in original if it is violation of the principle of natural justice. Now, what is the violation of the principle of natural justice? Suppose you made some submission and it is not considered. You made a written reply, it is not considered. The authority the order does not disclose the reason. It merely reproduces the allegation in the so-called notice, but in the operative part of it, there is no justification for confirming the demand against you. If that be the case, then you are very much entitled to approach the writ court to seek the quashing of the order in original. So if the order is non-speaking, then also it is violation of the natural justice. And if it is without jurisdiction, then also you can approach the writ court for quashing of the order. Now, the last thing which I wish to discuss today is the aspects of the special leave to appeal. Now, under Article 136 of the Constitution, any order or judgment of a high court, usually within that or the tribunal, can be challenged before the Supreme Court under Article 136. Now, under 136, there is a two-step process. One is admission of the SLP. When the Honorable Supreme Court exercises only its discretionary jurisdiction whether or not to grant the special leave to appeal. And if that is not granted, and you are dismissed at the threshold, then it cannot be said that the judgment of the High Court has merged with the judgment of the Supreme Court. So at that stage, when the admission stage, if it dismissed, it cannot be said. So many times I see that people rely upon a High Court judgment saying that it is a SLP is dismissed, so Supreme Court has decided so and so. No, it is not like that. Merely dismissal of SLP filed by the department or the SAC against the order of the High Court does not mean that it is an order of the Supreme Court, because there is no merger. Merger happen only when the SLP is admitted, and after the admission, the SLP, some order is passed. And if that order is a non-speaking also, then also it can be said that it is a Supreme Court order because there is a merger. But till that stage, there is no merger. So one must be careful about these aspects. So with this, I conclude my talk. I will take up some question and answer, and then we'll close for the day. One of the question of Mr. Chatterjee, Abir Chatterjee, is that while making payment of penalty under section 129 voluntarily, can appeal be filed? Yes, Mr. Chatterjee, definitely. Filing of an appeal is your statutory right, and that right cannot be taken away just because you have made a voluntary payment. Even if suppose in the course of the proceedings before the authority concerned, some admission has been made and some statement has been taken, still one can exercise the right of appeal. I have seen cases where the on voluntary payment, sometime the officer forcibly takes an undertaking that he will not file the appeal. Even if you give in writing that you will not file the appeal, you can always approach the writ court to file the, you can always approach the appellate authority for the purpose of filing of the appeal. Now, Mr. Falgun is asking how to check the judgment are overruled or not. You see, always you refer to the particular journal itself, and they themselves report as to what judgments are overruled. So you have to follow that particular journal out. Which are the relevant sections that we should keep in mind for the purpose of entering litigation? And some important case laws we should be relied upon. You see, for the purpose of handling litigation, the important provisions are section 73, 74, and 75. These are the most important sections because these are the sections which particularly section 75, which talks about the various procedural requirement as to the number of opportunity of adjournments, that the authority cannot go beyond the scope of the so cause notice, and what is the time period within which the adjudication proceeding should be concluded, and all that. But about the important case laws, you see, the case laws, there cannot be any general case laws which one can say which can be or should be relied upon while handling queries. While handling a case, it is always advisable to do a fresh research on the basis of allegation leveled against you by doing a quick research. But yes, of course, you can have a data bank of some of the common issues. For example, extended period of limitation, imposition of penalty, disputes relating to input tax credit, and all that. And I have in my previous slides have referred to some of the important judgments which can be referred to while furnishing your reply. So you should refer to those slides with respect to the particular subject matter and do a fresh research also. Penalty, yes, somebody is saying that is penalty paid 200% under section 29, still 25% pre-deposit to be made. No, not at all. Suppose you have made any payment, even suppose with respect to those 20% and 20%, any tax payment made during the course of investigation or inspection, that will be considered as a pre-deposit. So if 200% penalty has already been paid, then further 20% is not required to be paid. What is the date by which DRC 01 to be passed by the department? Now let us refer to section 75 subsection 10. The adjudication proceeding shall be deemed to be concluded if the order is not passed within 3 years as provided for in the subsection 10 of section 73 or within 5 years as provided in subsection 10 of section 74. So please refer to section 75 subsection 10. Certified copy of the order, at present certified copy of the order is still to be submitted. Yes, within 7 days you must submit a copy of the certified copy of the order while filing appeal, or rather after filing online appeal. Sir, when will be getting the slides and what document? The taxation people will themselves send you the copy of the PPT as well as the reply. I am also giving my email ID and somebody is asking for my contact number also. That also I have given in the chat box. My email ID as well as my contact number. Any more questions? So, madam, we can conclude our today's session because I think there are no more questions to be
Yes,
asked.
if there is no more questions left, we can wind up the session for today.
And we can do our next session on 20th, same time, 3 p.m.
Yes, sure, sir. Noted.
So that will be our last session. So 20th of May, we'll be conducting our last session.
Yeah, noted, sir.
And I will also, sorry, I mean, I've been telling again and again to give you the details of that economic offense itinerary. So that I will give you in a few days.
Yeah, thank you so much, sir. Yeah.
And we will decide, we usually decide the date also.
Yes, sure. Shall we wind up, sir?
Yes, yes.
Thank you so much, sir, for the session. And thank you everyone for joining today's session. We can meet in next session. So thank you so much. Bye, everyone.